All right, good evening, everybody. Thank you for coming. This is the maybe 17th annual Evil Twin Debate brought to you by the University of Richmond's IP Institute. We're some guesswork involved, including with the definition of the word annually, but it's something in that neighborhood. I know a lot of you have been here before, but for those of you who haven't or need a reminder, this debate series is founded on the notion that a lot of us in the IP community are sort of at loggerheads over particular issues, but remain really friendly on a personal level. And so the idea is to bring together a pair of scholars who can debate an important contemporary issue, but maybe, take some humorous pot shots at each other along the way. Sort of serious in substance, lighthearted in tone is sort of our approach. Our topic tonight is free speech or free riding. Does the First Amendment trump trademark law? I'm not going to tell you how many emails among 4 or 5 of us it took to come up with that slightly funny but still somewhat informative title. In recent years, the Supreme Court has taken an interest in the intersection of free speech and trademark. Disparaging marks, scandalous marks, parodies, former presidents' names and appendages. The list is long and growing. What do these cases mean for dilution liability, for self-expression, and for other important trademark issues? Our evil twins today are Lisa Ramsey and Jake Linford. That's all I'm going to tell you about them. I'm not going to tell you any more about them because, as is tradition to strike our lighthearted tone, we do away with the usual practice of asking each speaker to submit a bio and instead ask each speaker to submit a bio for the other speaker. These two in particular have asked not only could they write the bio, but could they read the other person's bio. So I'm going to be vacating the stand very quickly. What's going to happen is Jake's going to get up. He's going to read his bio of Lisa, then Lisa's going to read her bio of Jake, and then Lisa's going to give sort of a 3 to 5, 6 minute introduction to the issue, another dozen or so minutes of her argument. She'll then sit down, and Jake will have about 15 minutes to give his side of things. Lisa will have a few minutes for a quick rebuttal, and then we're going to round out the hour with a Q&A from the audience. So with no further ado, please welcome Jake Linford to the stand.
It is my distinct pleasure to introduce my evil twin, Lisa Ramsey. Lisa Ramsey is professor of law at the University of San Diego, ranked number 2 behind Pepperdine by students who say, "Class, on a day like this?" She earned a BA in kicking it and a JD covering the first 10% of the Bill of Rights from UCLA. UCLA's innovative grading system ran from best to worst as follows: radical, gnarly, goof, and bit it. I have not seen Lisa's transcript, but I suspect she never bit it on an exam. Her big law career started at what we now call DLA Piper's San Diego office, and what we used to call, what were the names of those 4 named partners? After transitioning to her own law practice for a year or 2 and finding that the rent was too damn high, she moved to the University of San Diego's swanky office space in gorgeous Linda Vista, California. Before joining USD, she clerked for the Honorable Rebecca Beach Smith in Waterford, Norfolk, Virginia. She also visited at Melbourne Law School in Australia and Victoria University of Wellington, New Zealand. I'm beginning to wonder if, like Ken, Lisa's job is also beach. Lisa teaches many fundamental courses at USD, including First Amendment and trademark law, why international IP regimes should adopt the First Amendment to the US Constitution, trademark litigation as an affront to free speech, and civil procedure. Lisa is under contract with Cambridge University Press to produce a book tentatively titled Free Speech for Heroes, Trademarks for Zeros. She has written many law review articles. Those that do not mention the First Amendment, zeros. At USD, Lisa received the prestigious class of 1975 endowed professorship granted to the faculty member most proficient in rock and roll trivia about albums recorded in, you guessed it, 1975. Lisa won by correctly identifying No More, No More as the second track on the B-side of Aerosmith's Toys in the Attic. She's also the recipient of the Nigel Tufnell of Spinal Tap First, the doubles are intentional, Amendment Amplified Chair of Law. It's a tiny little chair about 18 inches high with an embedded amplifier. Like Lisa's love for the First Amendment, all of the knobs go up to 11. In addition, Lisa is a quasi-rock star in her own right. She knows Adam Gimbel of Geezer, the world's greatest Weezer tribute band, and she's related to the guitarist of 1973 Revisited, who also plays in the School of Rock house band. In summary, Lisa Ramsey rocks.
Thank you, Jake. Hello, everyone. Thank you for joining us today. Here's my bio for Jake, my evil twin. Jake Linford is the Lula Fuller and Dan Myers Professor and Associate Dean for Research at Florida State University College of Law. He's an expert on trademark and copyright law, and his scholarship is published in leading law reviews and books. Some say that Professor Linford's real expertise, however, is in celebrating the music of David Bowie. Professor Linford includes words from Bowie songs in the title and all of the headings of his interesting book chapter about the trademarks of music groups, Tell the Truth, Truth in Music Advertising, post-TAM. Rumor has it that students want him to teach a Bowie and the Law class at Florida State. So Jake is also an expert storyteller in his writing and in real life, as demonstrated by his top-notch job as dungeon master for the Dungeons and Dragons role-playing game the last time Whip Whip was held at Santa Clara. Professor Linford has received several honors and awards during his career as a law professor, including the Lattice Memorial Award for the top professional trademark paper in 2017. This paper, titled Are Trademarks Ever Fanciful?, is part of his series of excellent law review articles that examine the topic of conceptual distinctiveness in trademark law. If professors were trademarks, many would classify Professor Linford as a strong, fanciful mark on the Abercrombie spectrum of distinctiveness. This is due to his past display of a handlebar mustache, his bow ties, which he's not wearing one today.
I've rebranded, it's
Past use of bow ties and handlebar mustaches, his love of music and running, and the fact that his 4 sons are named after famous jazz musicians. Professor Linford is also known for his attempts to invent new words, like genericide and tarnish myths. Some mean girls I know say that he should stop trying to make fetch. I mean, those words happen. His 2023 co-authored paper, Trademark Tarnish Myths, highlights his co-authors and his important empirical research on whether certain uses of famous marks in connection with cannabis products or sexually explicit or satanic-themed advertising harms the mark's reputation in a manner that constitutes dilution by tarnishment. So, if you catch him at a conference with a bag of cannabis-infused Skittles or disreputable images on his laptop screen, you can be sure that this is all just for research. All right, one last interesting fact about Professor Linford is that he is an advanced speaker in Haitian Creole. His presentation style at conferences and his ability to persuade others is so effective that he has agreed to present his side of the debate in Haitian Creole. All right, so now I'm going to shift to my presentation. So I want to thank Jim Gibson, Chris Katropia, University of Richmond School of Law for hosting our Evil Twin debate and inviting us to speak. I also want to thank Jake Linford for being my evil twin, and thank Santa Clara School of Law for hosting Whip Whip. I look forward to that. Unfortunately, I have to leave on Friday night, so I hope I can visit with you all tomorrow, since I won't be there on Saturday. So the question for us tonight is whether the free speech right in the First Amendment trumps trademark law. After the U.S. Supreme Court's decisions in Mittal versus Tam and Iancu versus Brunetti, it's pretty clear the answer is sometimes yes. I will first introduce this topic and recent Supreme Court cases that discuss actual and potential conflicts between trademark and free speech rights. Then I will argue that the Supreme Court will and should continue to protect First Amendment interests in trademark law. The justices may do this in several different ways. First, the court might strike down more trademark laws on the ground that they discriminate based on viewpoint. Perhaps they'll apply traditional constitutional scrutiny analysis to trademark laws, like Justice Alito did in his plurality opinion in Tam. dilution law is an example of law that may be struck down after Tam and Brunetti. Second, I think the court may approve of more speech protective trademark doctrines that are developed by lower courts that enable the early dismissal of speech harmful trademark claims. It already did this for the parody defense in the Jack Daniels case, and I think there are other defenses it might approve of. Third, the court may create its own speech protective limits on trademark rights when it interprets a statute by focusing on three things. Number one, the purpose of that trademark law. Number two, the fit between the means and ends of that law. And then number three, how that law may harm freedom of expression. In the Jack Daniels case, the court actually kind of walked through these three different things, which is actually similar to constitutional analysis. So even if the court may not actually apply intermediate or strict scrutiny analysis, I suggest that you look for these three things in any opinions that you read from the Supreme Court. And I think the court may use this approach in Elster. It's not clear whether they'll apply intermediate or strict scrutiny analysis, but they may also use this approach if they consider the constitutionality of trademark failure to function doctrine. So after Tam, we know that trademark laws implicate the First Amendment. Substantive trademark laws regulate the content of speech. Some also regulate the viewpoint of speech. Courts might invoke this constitutional provision to strike down laws that are not narrowly drawn to further substantial or compelling government interests, or are laws that may harm expression more than necessary. In Tam and Brunetti, the Supreme Court struck down the Lanham Act Section 2A's ban on registration of disparaging, scandalous, and immoral trademarks on the ground these laws discriminated based on the viewpoint of expression. After Tam and Brunetti, many trademark experts wondered whether the court may conclude that other trademark registration laws conflict with the First Amendment. One example is Section 2C of the Lanham Act. This law protects the rights of publicity and privacy of living individuals and deceased presidents by preventing the registration of another person's name, signature, or image without consent. A First Amendment challenge to this law is currently pending at the Supreme Court in Vidal versus Elster. The USPTO refused to register Steve Elster's proposed mark Trump Too Small for t-shirts by citing Section 2C of the Lanham Act. Elster argues this law is unconstitutional as applied to his critical political message. He claims to have a First Amendment right to register this trademark for t-shirts. Now when the Supreme Court granted cert in Elster, many people thought the court would hold this law as unconstitutional, just like it did in Tam and Brunetti. I didn't, but some people did. One reason is that this law applies to commercial and non-commercial speech that is not fraudulent, deceptive, or misleading. After the oral argument, Elster, pretty much everyone agrees, though, that the court's going to uphold the constitutionality of Section 2C. I think the court's decision will probably focus on the fact that this law is a viewpoint-neutral law, which distinguishes it from Tam and Brunetti. Also, I think the court will point out that the law does not prevent Elster from using this political message. Of course, this was also true in Tam and Brunetti, but the court will just kind of burst that argument. Many people hope, including me, that the justices will provide more guidance on trademark law. They don't have a good track record so far, but will provide more guidance on how to navigate any potential conflicts between trademark and free speech rights. So more recently, in Jack Daniels versus VI Products, a case from 2023, that involves parody dog toys, the Supreme Court considered whether to approve of a judge-made speech-protected doctrine that evaluates claims of infringement. This is called the Rogers test. The Rogers test is traditionally applied when someone uses another's mark in the title or content of an artistic or literary work, right? It might be a movie, a television series, a book, video games, other types of expressive works. In the Ninth Circuit, Rogers provides that courts should not apply that standard multi-factor likelihood of confusion analysis unless this unauthorized use of the plaintiff's mark is not artistically relevant, or this use explicitly misleads as to the source or content of the work. If this use of the mark in an expressive work is artistically relevant and is not explicitly misleading, courts will often dispose of the case early on a motion to dismiss or summary judgment motion. And this is good, right, for artists, authors, small businesses who can't afford to litigate to trial or even through discovery, right, to get a successful judgment in their favor. And Jack Daniels VIP Products sold a bad spaniel parody dog toy that poked fun at Jack Daniels' iconic brand name, the shape of its bottle, and also the black and white label design. Importantly, the Supreme Court didn't approve or disapprove of the Rogers balancing test in its decision this last year. Instead, the court narrowly held that Rogers cannot apply if the accused infringer is using this expression as a trademark for its own goods or services. The court also held that an accused party cannot invoke the non-commercial use of the mark exclusion from dilution liability in the Lanham Act if it is using the expression as a mark in parody, criticism, or commentary. And the case now has been remanded, so we'll see if VIP Products is held liable for infringement or dilution below or not, right? Now, this holding with regard to the dilution provision was surprising because that statutory provision doesn't actually have a non-trademark use requirement in it, unlike other parts of the Act. However, other parts of the Jack Daniels decision are speech protective. And I think they signal that the court believes the First Amendment provides limits on trademark law. So now I'm going to set forth my argument. Right? I believe the Supreme Court will and should continue to consider First Amendment interests in trademark law. Now, I admit the court might be a little bit wary about creating or adopting new speech protective defensive doctrines when it enforces trademark, when it interprets trademark enforcement laws. However, Justice Alito, one of the court's originalists, noted during oral argument in Jack Daniels that the First Amendment is a text that says Congress shall make no law abridging free speech. This law takes precedence over the Lanham Act, according to Alito. I think that's important. The justices have never held in a trademark dispute that trademark law always trumps the First Amendment. And I think certain aspects of the Jack Daniels decision suggest that expressive values can influence trademark disputes. For example, the court approved of the speech protective parody defense and actually cited the Louis Vuitton versus Hot Diggity Dog case that applied this kind of higher kind of threshold for infringement as you walk through the likelihood of confusion factors. The court also stated in a footnote that trial courts can grant motions to dismiss an infringement claim in trademark disputes if the allegation of likely confusion is not plausible. And this might be because the parties' marks are dissimilar or because of the context of the use, maybe if are you using it as a trademark or not, or what the goods and services are that display the mark. The Jack Daniels court also emphasized the source identifying function of trademarks in the Jack Daniels case and repeatedly talked about source confusion being the main concern of trademark enforcement laws. That's important because a lot of folks say that perhaps we shouldn't have a finding of infringement if people are just confused about affiliation, approval of the trademark owner in a certain context where someone's engaging in their free speech right to express ideas or information. So again, it's important the court did not hold that Rogers or another threshold First Amendment test can never be applied to determine infringement in trademark disputes that may suppress protected expression without a proper justification. It's important too that certain members of Congress, right, indicated they approved of the Rogers test in a House report that was prepared in connection with the Trademark Modernization Act a couple of years ago. It's unfortunate the court didn't cite this in Jack Daniels. It was cited in various amicus briefs filed with the court. But the fact that certain members of Congress approve of Rogers may matter to some justices or to some judges if they later on reconsider whether to approve of Rogers or perhaps a revised version of that test. It's also important that Justice Sotomayor's concurrence in Jack Daniels was joined by Justice Alito, urged courts to exercise caution when considering consumer survey evidence. When determining infringement liability, she said courts should not focus on whether the public is confused about what the law requires, right? That courts should also not focus on whether a certain accused infringer needs permission to use the mark. So I think language in the concurrence may help some accused infringers to protect their free speech rights. It's true Justice Gorsuch wrote a concurring opinion that was joined by Justices Thomas and Barrett, which indicated they had some concerns about the Rogers test. However, questions raised in oral argument suggest that they still think the First Amendment provides limits on trademark rights. I think one of their main concerns is probably the no artistic relevance prong of the Rogers test. And I also think that this should not be part of any speech protected test. Christine Farley and I have co-written an article that was recently published where we get rid of that prong of the test. In some sense, it's a little bit like a revised version of Rogers. And I encourage you to take a look at that if you're interested in this area of the law. It's called Raising the Threshold for Trademark Infringement to Protect Free Expression. So I think that they're concerned about that prong. They may have also been concerned that some lower courts suggested that Rogers actually replaced the likelihood of confusion standard in the infringement statute. I think one way to look at Rogers or other proposed speech protective tests, like our test or the dominant fair use test, is this is a test that's interpreting the likelihood of confusion language in a way that kind of ensures that the law is not unconstitutional. So it's the doctrine of constitutional avoidance is kind of a way that you can allow these kinds of interpretations of the law. Importantly, during oral argument, Jack Daniels, a few justices indicated that they believe the display of political messages on the front of t-shirts is protected by the First Amendment. Now, the Rogers test doesn't clearly apply to the display of words and designs on the front of t-shirts. And we don't have a good statutory or common law defense to protect those kinds of uses. The Ninth Circuit did hold that the display of "Let us turn up the beat" on the front of a shirt was an aesthetically functional use that was not infringing in a case, but that's like the only case that I know of where this has happened. So aesthetically functional, decorative uses of marks may be allowed, maybe under kind of interpretation of failure to function doctrine, but it would be great if Congress could actually enact some statutory defenses and provide more certainty and predictability in trademark law. One limitation of the Rogers test, right, is that some trademark advocates, some courts think it should only apply to traditional artistic and literary works that have titles, right, books, movies, television series, etc., and not to informational or expressive or decorative uses of language or designs that are claimed as trademarks by others. And so I think it's important that we consider whether there are fair use doctrines that we can have either in the statute or the common law that will protect this kind of expression from suppression by the government in trademark enforcement suits. History may also be important to some justices as they determine how to balance trademark and free speech right. History came up in the Elster oral arguments, and a lot of folks have noted, right, that the expansion of trademark law, so no longer that you have infringement law applying to source confusing uses of trademarks. You can have infringement based on affiliation or sponsorship confusion about approval. And then of course we have the dilution statutes, which don't even require this use to be confusing. It doesn't require any evidence of actual damages. So that is problematic. Graham Dinwiddie and others have pointed out that we've had these expansions by courts, by Congress, but we also haven't had an expansion of the defenses that would apply. So we have descriptive fair use that enables you to use descriptive terms, otherwise known as a trademark. But we have no fair use defense for use of colors or product designs or political and social messages where you might be using this language, this design for its inherent meaning, right? Or its inherent decorative value and not because of a source significance provided by that expression. There's no exclusion in the infringement statutes for parody, for comparative advertising, for consumer product reviews, for use of another's mark in non-commercial speech, in artistic and literary expression that was at issue in Rogers. There's no nominative fair use doctrine in the infringement statutes, but we see that in the dilution statutes. So my hope is that the Supreme Court will change this if Congress doesn't actually make a change in the statutes. And if you're curious about the various trademark doctrines at issue that do protect speech interests and trademark law, again, Christine Farley and I talk about the options in part 2 of our paper and propose a new fair use defense in the third part of our paper. So kind of, again, going back to my 3 arguments. So let's see, thank you. And so dilution law, right, again, so what are the 3 major areas where I think there's gonna be a change? I really actually predict that the court will strike down trademark dilution law, at a minimum trademark dilution law. Right? This law regulates offensive speech. And it's actually worse, right, than the laws at Tam and Bernetti because the courts are actually suppressing speech, right, not just chilling the speech of people who might want to use it as a trademark and prevent other people from using the same mark with their goods or their services. Now, the free speech challenges to trademark law after after Tam paper actually has my kind of detailed argument as to why dilution law is unconstitutional. But the highlights are that the harm is speculative. That's not allowed in First Amendment law, right? The law is over and under inclusive, a point made by Rebecca Tushnet, Mary LaFrance, and others who've written about trademark dilution law. And if you think about the impact on freedom of expression, dilution law can apply to any goods and services, right? Not competing goods, not identical goods, but any goods and services. So this stifles speech across industries based on a speculative harm. I think that's very problematic. Jake Linford has an excellent published paper and a work in progress paper that he's going to be presenting at this conference that talks about the harm that's caused by tarnishing uses of another's famous mark. And so I definitely recommend that you check that out. Let's see. And then finally, dilution laws, I argue in my paper, discriminate based on viewpoint. So I think that arguably strict scrutiny analysis should apply, although it's not clear the court's going to do that. But still, even under intermediate scrutiny analysis, I think that dilution laws will fail because the reason they discriminate based on viewpoint is they're favoring the famous brand owner's message over the non-confusing message conveyed by the accused party when it uses an identical or similar language or designs in a non-confusing way in connection with the sale of their products. And again, that dilution and tarnishment provision actually targets offensive speech, so that's very problematic after Tanning Burnett. With regard to infringement law, I want to wrap up here. I think that there's a chance the court may not approve of Rogers as it stands, but maybe a revised version of Rogers. Perhaps it will consider other kinds of speech protective defensive doctrines, maybe a defense for non-trademark use of the mark in non-commercial speech. That would cover the display of words or designs on the front of a t-shirt in addition to artistic and literary expression. And then finally, with regard to kind of this an analysis that's not really intermediate or strict scrutiny analysis, but some kind of a constitutional-like analysis, I think the higher court and lower courts will pay attention to the purposes of trademark law after Tam and Bernetti and Elster and Jack Daniels. Some scholars don't like constitutional scrutiny of trademark law, but they're fine with a purposivism, I can't say the word, purposivist interpretation of laws, right? What's great though about the First Amendment scrutiny is it requires you to identify the purpose, talk about the fit between the means and ends of the law, and then talk about how the law may harm expression. So what I encourage the court to do, I encourage attorneys to do, is to talk about those three things when a law might implicate informational or expressive uses of trademarks or decorative uses of trademarks. And hopefully you might be able to convince the court that in this particular context, trademark law should not apply. Last, I just want to mention failure to function doctrine. It's kind of the hot new topic. I recommend Alex Roberts' great paper on failure to function doctrine. Eric Bernetti, after being able to register FUCT, then applies to register fuck. And the trademark office says this word fails to function as a trademark, right, for shirts and retail store services or whatever, I forget all the things. I think it was jewelry, retail store services. And so he and others, including the applicant for the Everybody versus Racism mark, have said this violates my First Amendment rights, that we can't register these marks. And the trademark examiners, TTAB Federal Circuit recently have said no, this doesn't. And I think the court's going to agree. And I hope that the court will either apply intermediate or strict scrutiny analysis or walk us through the purpose of the law, the fit between means and ends, and the harm to free speech. And note that if you refuse to register informational or expressive or decorative subject matter, that means it remains in the public domain, available for use by everyone. So thank you to Richmond for inviting me to speak, and I look forward to hearing from my evil twin.
Alors, Lisa te pomet, non creo la ICM. Alors, quien be fem. Now wait. Okay, I'm not actually going to do that. But I could. Thank you, Jim. Thank you, Chris. Thank you, Richmond. Thank you, Lisa. May it please the court, I retroactively cede 3 minutes of my time to opposing counsel. So, my thoughts are a little less organized than Lisa's, but they run along 2 tracks. First, what is the court likely to do in a post-Jack Daniels about to get too small with Trump Elster universe? And I think the answer is not very much more than they've already done. I think the court has sated itself on Tam and Brunetti as far as its willingness to take big bites of First Amendment law in the trademark space. I could be wrong. I think if you have a majority of the justices who find arguments persuasive that you ought to do more robust First Amendment stuff, I think Lisa's prescriptions would be fantastic. I don't, however, think that that is the right move for trademark law, so I'm going to talk a little bit about why I think the court's not going to do much more, and I'm going to tell you why I think that's probably the right move. A big part of this debate about using the First Amendment is about the question of, are our policy prescriptions into trademark space shaped by constitutional pre-commitments, and how severely does the Constitution bind us in what we can do in commercial regulation? When you talk about this question of purpose and fit and harm, if we're applying strict scrutiny in every context, right? The government's got to show a compelling interest, and they've got to use the least restrictive means necessary to meet that interest. That opens up a lot of room for constitutional nullification of all sorts of statutory provisions, and the Lanham Act, many parts of it, wouldn't be immune to that. I do think the core of trademark law as a passing off doctrine, I think if you ask the justices to say, is there a compelling reason for this, and at least the core of passing off, is it no broader than necessary, I think that I'll say yes. And I think that because when you see them talk about trademark law generally, at least that basic passing off maneuver, they see that as well within Congress's bounds and an appropriate use of congressional authority to provide both an incentive for mark owners to communicate with the public and as a tool for the public to use these trademarks as a way to find the goods they want. Now, with regard to scrutiny, what level of scrutiny is appropriate? We saw in a fight between the government and a hopeful registrant, the Supreme Court disagreeing a little bit as to whether it wanted to use strict scrutiny or intermediate scrutiny, but in either case, the way the court has treated its intermediate scrutiny recently, post-Sorrell, post-Reed, its intermediate scrutiny is pretty stiff, right? And it starts to smell a little bit like a least restrictive means test. And once you start kind of swinging around a least restrictive means test, you're going to have a hard time getting a disparaging mark bar or a scandalous mark bar as a basis for keeping a hopeful trademark registrant out of the trademark office. That's not the only type of scrutiny we can imagine. Every time the Supreme Court's been invited in the last 20 years to think about constitutional scrutiny of copyright law, the scrutiny that's applied is a rational basis scrutiny, which feels to some of us like no scrutiny at all, but it isn't. It's just a presumption that unless Congress has done something really untoward, and the way Justice Ginsburg described this in the Elder case is we're going to violate one of two traditional contours, which she clarified in Golan. It was only two traditional contours, right? But it's the fair use doctrine or the idea expression divide. If Congress violates one of those, probably, then we would apply some sort of heightened scrutiny. Otherwise, it's kind of rational basis. And if you look at some of these intermediate scrutiny cases, what you find in some of them is we end up talking about fit. Is there a fit between what Congress is trying to do, what it's trying to accomplish, and what it's done? And sometimes that fit looks like a rationality test. And if you've had a chance to kind of pick through the oral argument in Elster, what you see is a court trying to figure out, aren't there some levels of scrutiny that are a little bit lower than, heightened strict scrutiny or intermediate scrutiny, and what does that look like? They're trying to figure out what to name it for big chunks of that oral argument. Everybody seems disposed to find 2C as constitutionally valid, and they're just trying to figure out how they're going to describe why it's constitutionally valid. This is what we do with these tests all the time, right? My meta concern about this conversation is we are trying to cloak policy determinations about what trademark law ought to look like in essentialist First Amendment terms that I'm not sure are always entirely helpful in resolving that problem. Now, Justice Alito loves history, Justice Gorsuch loves history. The jury's still out as to whether history loves Justice Gorsuch, but leaving that to the side, you look at the first 100, 150 or so years of interaction between trademark law and the First Amendment, and there is none. Now, this may be a presumption that the First Amendment just didn't reach commercial speech, and the Supreme Court really didn't reconsider that until the Virginia Board of Pharmacy case in 1970, in the 70s. Don't ask me to quote you on a year, I can't. But there's this presumption that these two circles in the Venn diagram just didn't really overlap a whole lot. Now, maybe that's because, and this is an argument advanced, that trademark law was just so narrow, it was just passing off. And so how could the First Amendment possibly reach it? So the First Amendment, trademark law kind of expands over time, both judicially and statutorily, and everybody's got their favorite bête noire. It usually starts in initial interest confusion, perhaps post-sale confusion, perhaps tarnishment. But the history seems to suggest that for a long time there wasn't much overlap. And even as the overlap starts, even as you get to the central Hudson test, right, there are a couple of signposts along the road that suggest to me at that point in history that, look, this is a brand new court, right? But at that point in history, I think the justices would have looked out over the world and they would have said, like they said in a case called Tanner, free speech rights don't allow you to trespass on somebody else's property to make your point. And as they said in SFAA, we have the phrase they use, a misappropriation of some intangible property right, even if it's speech. That's not an exact quote, but this idea that there are rights in these things that one person might have an interest in, kind of communicating who they are, and the fact that you also have something to say doesn't necessarily allow you to trespass on those rights. And that's how the court was thinking about that intersection between the First Amendment and trademark law, really up until Tam. There are some exceptions, they aren't very big ones. You want to argue about the exceptions, we can get down in the weeds and arm wrestle. I'm happy to do that. You'll probably pin me, I'm not much of a wrestler. Now, with all those signposts in the road, we then see Tam and Brunetti, and Tam and Brunetti seem like big drastic shifts. They felt to me like huge shifts in the trademark world, and I thought, well, after Tam and Brunetti, of course, Jack Daniels is going to go in favor of the squeaky dog toy maker. Nay, not so. And I asked myself, well, what's happened here? And I thought, and I thought. And I think there's two theses. The one is less satisfying, but I'll give it to you. The Supreme Court took two big bites, its belly was full, and it was done. And the second is, I think they see JDI, and they see Elster, and they see much of trademark law as distinctly different from the dispute in Tam and Brunetti. For a very simple reason. The dispute in Tam and Brunetti is a fight between the government and a hopeful speaker. And the fight in JDI, and the fight in Elster, and lots of trademark fights, are fights between two potential speakers. Someone who was there first, whatever we think that means in a use-based trademark system, and somebody who comes along second, and both of them have got claims to the term in dispute, or the trade dress, or the source signifier in dispute here, and then we got to figure out what we do with it. But once you add that third party, instead of having a binary where it's government versus speaker, and the court knows what to do with that, right now it's tell the government they lose. Once you add that third party and you start triangulating, then you have a little bit different conversation. And if the court is disposed, and it seems disposed if you look at the Elster oral argument, to think of trademarks in a property sense, or to even perhaps make up a new federal quasi-federal, quasi-right of publicity out of whole cloth, or out of the old bar on getting trademark rights in personal names. I still don't know where Gorsuch got that. I'm really excited to see if he writes an opinion, because I want to see.
Jennifer Rothman has paper.
Does she have paper? Oh, I need to see his paper.
Yeah, it's in my book.
Okay, yeah, send it to me, please. So I think that's what's going on with the court. I think they see these cases as different. Now, my view on the court's view on Rogers is a little less sanguine than Lisa's. We had the three justices concurring who look at Rogers basically like the old number 2 on the Lanham Act, which is to say, it's just not really appropriate to go crafting non-statutory defenses. Now, I'm not sure I agree with that. It feels a little bit strong. It feels a little bit strong if you look at the history of what our likelihood of confusion test is, which a bunch of tests that courts have cooked up over time. That said, when you have a test that kind of grows over time in the Ninth Circuit to be a test where if I can see anything that looks kind of expressive, all of a sudden we've got an opening to dispose of the case at a very early stage. And once the court said everything in trademark law is kind of expressive because it kind of is, you see then you have an opening where instead of putting a thumb on the scale, it's plausible that Rogers, at least as interpreted by the Ninth Circuit, was putting a fist on the scale. And I think the court saw that as problematic. So they pull Rogers back, I think, to its Second Circuit bounds. Find me an expressive work, something with a title, something that would qualify for copyright protection. Rogers seems right-sized for that job. Let's let it do that job. And then they propose, in other cases where there are some expressive interests, let's have a likelihood of confusion analysis. And much like parity reshapes the fair use analysis in a copyright context, parity may reshape the likelihood of confusion factors where we see there is some expression, but it is not an expressive work. And so you have cases like the O'Daly Dog case, like there's at least 2 more. There's the Starbucks case and the Timmy Holdaker case, right? Where you see these courts using this toolkit to reach what is probably the correct conclusion in a likelihood of confusion analysis, being sensitive to the First Amendment interests. Now, if those need to happen early, the court has invited the lower courts to dispose of some things on a motion for summary judgment. That's probably the right toolkit to use, as opposed to a categorical early rule. I want to say a couple things on tarnishment, and then I'll end. Tarnishment is tricky, right? Because like Lisa says, you don't have to squint very hard to look at it as a viewpoint-based restriction. And so a couple co-authors and I, we went looking to see if we could find evidence of tarnishment. What we did is we ran a bunch of surveys and asked a bunch of potential consumers, would you like to buy product A or product B? And in the test condition, product B was one we tarnished earlier, and then they had to pick between product B and something else. And what we found almost exclusively was a burnishment effect, and especially among political progressives. A little bit of a mixed effect among conservatives. If you were highly religious, you thought Chick-fil-A tasted worse if you were primed with the satanic Chick-fil-A sandwich ad. But other than that, not a whole lot. And we've got a pilot study that we're doing on whether there are things that do tarnish marks for progressives, and the answer seems to be guns, sexism, and racism. At least according to the pilot, that's the predictive pilot study, and then we've got to run a study and see if it cashes out. Now, if we don't find anything, and we didn't find anything last time, and lots of the studies seem to suggest there's not much tarnishment happening, and if you get enough studies that you begin to feel like you've got some sense of what the world looks like, then from an Alvarez-style analysis, this is the Supreme Court deciding Congress didn't have a basis to tell us to criminalize lying about whether you had a Medal of Honor, if you don't remember that case. If we don't have evidence of tarnishment, right, if tarnishment seems not to exist, then it's probably a pretty good candidate for some sort of constitutional nullification. On the other hand, if the evidence ends up cutting the other direction, or even if the evidence is mixed, I'm not so sure the right answer isn't to grant Congress some discretion in this space and to say, is there a rational fit between what Congress has decided to do or not? And my last meta point on the meta point is this. I think we have seen this court, as currently constituted, willing to use the First Amendment as a deregulatory crowbar. And I'm awfully anxious about anything that invites them to kind of broaden any of those crowbar uses, because I think then you end up with a First Amendment that ends up doing work like a Lochner 2.0, and we might get good things from the trademark doctrine, maybe, and terrible things overall in commercial regulation to the extent the court thinks it's got free rein to do that sort of thing. So I'm kind of a cautious no on essentializing First Amendment analysis of trademark doctrines. Thank you.
All right, my response. So first of all, trademark law is really a collaboration between Congress and the courts. So in the infringement statutes, we have the likely to cause confusion language, but the multi-factor test that requires you to consider the subjective intent of the accused infringer, to actually look at a consumer survey, that's not in the statute, as pointed out by some of the folks who filed amicus briefs in the Jack Daniels case. And so in a sense, those who think we automatically have to go to the multi-factor test and not Rogers or not if you're used or these other kinds of speech protective doctrines, again, none of those are in the statute. And so I think it gives courts some leeway to pick what might work best. And as Jake noted, commercial speech didn't used to be considered protected under the First Amendment. And as Mark Lemley and Rebecca Tushnet have recently pointed out in a new paper, in other areas of the law, the court's very much protecting commercial speech, right? And so why wouldn't they come back here to trademark law and protect commercial speech interests with the dilution law or the use of someone else's mark on the front of the t-shirt, right? And parody, criticism, commentary, but also uses for the inherent meaning of the language. For those folks who might think we should be protecting property rights and trademarks, I think that's Jake. So sometimes they cite language in opinions about we want to protect the goodwill and reputation, right, of the trademark owner. But one way you could look at that is that protecting against confusing uses of trademarks actually protects the goodwill and reputation of the trademark owner. So those who claim that these phrases mean that dilution protection is approved of by the court, I think that's the response, is that we don't have to protect dilution statutes to further those goals because to back up, the statute actually has a list of the intent of Congress, and protection of property rights and goodwill and reputation when uses are not confusing is not in the statutory language. There is language about preventing fraudulent, deceptive, and misleading uses of trademarks, right? Preventing unfair competition, etc. Let's see. I agree that there's been some questioning of whether or not the court might distinguish between First Amendment application in the registration context versus application in the enforcement context. So I will concede that the court might see those things differently. But again, the fact the court recognized that parity doctrine could be applied and recognized that if a certain trademark has an expressive content that could influence the likelihood of confusion analysis, indicates to me that the court thinks the First Amendment still does impose limitations in the enforcement space. And I think I'm just going to end there. So thank you very much.
Well, great. Thanks so much to our two twins. There'll be a survey later to follow up on which one is evil.
I think we know.
Yes, obviously. I mean,
He's gonna wear a mustache.
he has a handlebar mustache. It's not really, right? Like, am I wrong? Yeah. But we do have a few minutes left, and so happy to continue the conversation by taking questions from the audience in the back. Sharon. And I'll repeat the question so we get it on tape.
So, my comments are not going to be surprising, but one of the things that I think we don't do enough is kind of an interdisciplinary study of these issues. So particularly with the comment about third party, there's a lot of jurisprudence in trade secret law about that, and about the wrongdoing of the direct misappropriator not allowing a First Amendment defense in trade secret context. But if the information ends up with a third party, First Amendment defense can work more. So I would just suggest looking at that because, I'm in favor of more interdisciplinary examination of these issues.
That's a great comment. Thank you.
Sorry, let me just repeat it real quick, just in case people didn't hear. So, Sharon, correct me if I'm wrong, but it's essentially we might be able to borrow some helpful doctrine and thought from the notion that in trade secrets we actually have an existing jurisprudence about the role of the First Amendment, particularly when you're talking about sort of third-party responsibility for the primary infringement.
Okay.
Now you can respond or not.
So
one thought on that, and I don't know if this is direct or not, so there's a danger. I'll try to be brief. One of the things that I'm trying to work through, a lot of Tam and Brunetti are very speaker focused. They're not terribly audience focused. You can imagine an audience focused version of Tam and Brunetti, and Tam's probably got the better story, right? We're trying to retell, we're trying to reclaim this racist stereotype. Okay. Brunetti just wants to swear on a t-shirt, and that's okay too. I mean, that's fine. But there's not a real good story there, right? There are stories you can tell in parody contexts, right, where maybe consumers need to hear this sort of thing, or there's some interest of the consumer in receiving this expression. And so that's what your third party comment kind of struck with me, where there may be stories that are easier to tell from a defensive standpoint because the defendant is kind of invoking things for other people. So descriptive uses, failure to function uses, those seem like an easier space for that sort of story. But the classic story we've told, and I think for good reason, is a story that by and large we want to avoid confusion of consumers, and we have been fairly generous, and by we, I mean courts have been fairly generous in how they're defining what confusion means, or what actionable confusion means.
Actually, I do want to follow up. So Jake had mentioned copyright law and then with regard to trade secret law. So I think it's helpful to consult other areas of IP law, just like it might be helpful to consult maybe what foreign countries are doing in a certain space. But in the end, trademark law is very different than copyright law or trade secret law. So in copyright law, right, we have the idea expression dichotomy, we have a very broad fair use defense. In trademark law, we don't have a very broad statutory defense. And we know after Qualitex that almost anything can qualify as a trademark if it has source distinguishing meaning. So one concern I have, is that the court might just come up with some sort of like test that's like what we saw in Elster. Oh, as long as the traditional contours, are not changed, First Amendment scrutiny is not required. And so, some folks have written about this, Eugene Volokh and others, and so that's something I hope the court doesn't do.
Thank you. Yeah.
I'm glad that Lisa's out there fighting for the First Amendment, but a couple of things in this court's opinions that I think challenge your view and support Jake's. One, in the Jack Daniels case, they not only said that you can't use Rogers, they said you can't use any threshold test. You have to go to likelihood of confusion. And then in San Francisco Arts and Athletics, in dicta, and granted it's dicta, the court has already blessed dilution law. I agree dilution by tarnishment's on shakier ground. Dilution by blurring is not going anywhere, but dilution by, those are two strong indications that Jake may be right.
Okay, so I have a response.
Yeah, sorry, I just want to get it on. Just to repeat real quick, the question was.
Clear, not morally right.
Just predictably right.
Heavens forfend.
Real quick, that what the court actually said in Jack Daniels is you don't get a threshold test, you have to go right to likelihood of confusion. Of course, likelihood of confusion itself is in the statute. And secondly, in the San Francisco case, they already sort of blessed dilution to some extent, and so there's a headwind there.
Yes, so there's that language, I agree with you, that says any First Amendment threshold test, and then there's other language to say normally the standard likelihood of confusion test does enough work to protect First Amendment interests, except for in rare situations. And so that rare situations is the hook for anyone that wants to argue that this non-trademark use requirement shouldn't prevent application of First Amendment scrutiny. And so examples would be the Punchbowl News case, Empire case, where the Ninth Circuit actually applied Rogers to trademark uses of marks. It's frustrating that the court didn't mention these cases. So I wonder what other cases might fit in that rare situation kind of area. But right, I think the way you think about it is nominative fair use doctrine, Rogers, both are supposedly supplanting the likelihood of confusion test. And so the way you need to address that is to say, no, they don't supplant it. They're just interpreting it in a speech protective way. Or with aesthetic functionality doctrine, that's a defense that is actually in the statute. Normally, we focus on the plaintiff's functional use, but that's what was interesting about Let Us Turn Up the Beat, is they focus on the defendant's aesthetically functional or decorative use. And then with regard to San Francisco athletics, I agree, it occasionally frustrates me, it seems so outdated, it's cited in dicta, and again, just with copyright law, I would say, Christine Farley and I kind of note in our paper, right, that these cases are just, they have different laws, they have different goals to the Lanham Act. The law protecting the Olympic marks, that's for those who don't know, San Francisco athletics. They tried to stop use of the Olympic Games because it had the word Olympic in it, so I think that's my hope, is that the court will recognize this. But it is true, during oral argument in Elster, I think it was Justice Alito said, "Oh, well, how about let's look at San Francisco athletics? Maybe this supports an argument for upholding Section 2C." So we'll see what the court does with that, if anything.
Maybe time for one more question. Sorry, you're good. All right, folks. Well, the bar remains open, I think, for another half hour, and the food remains available. But let's thank our one evil and one non. Thank you all for coming.
That was great. That's fun.
Thank you so much for that.